Better before the court this meeting is Leonhardt, the city of Akron. As you gentlemen are aware, each party will have 15 minutes in which to present the case. The appellant may reserve up to 5 minutes for rebuttal. If you're the appellant who wishes to reserve some of that time, let me know when you come up to the podium. And keeping track of the clock will keep you apprised of the passage of time. We are being visually and audibly recorded and be posted online, so please try to remain behind the podium as much as possible. We have written briefs and we're ready to proceed with yours.
Thank you. May it please the court. Attorney Lowry for the appellant, 003117. Using my voice, you know, the day of. Regardless, I represent Dr. Leonhardt in this case. I guess what's a little bit unusual about this case perhaps is that I don't know over the years that I've done many, if any, quite frankly, appeals based upon the grant of a motion for summary judgment. I think part of that is because it's a remedy that is not to be used extensively, and so it's you know, I consider it to be kind of sort of an extraordinary remedy, and you know, just I guess reiterating, everybody, you know, you see the standard all the time in every brief you get, but under the Houndshell case, I mean, it's clear that the court should not enter a summary judgment if it appears a material fact is genuinely disputed, or if considering the allegations most favorably towards a non-moving party, reasonable minds could draw different conclusions from the undisputed facts. This is a case that involves what arguably is a routine traffic stop, and during my dissertation, I'm going to allude to what I call in my brief the IVS, the inboard video system. There is a video of this encounter. Unfortunately, the video captures predominantly the audio portion of what happened because of the geometric configuration of the police cruiser and my client's car. But the audio is pretty good, and in my brief I point out that I've asked the court, I think it's the most integral piece of evidence. I consider it actually to be analogous to a witness, and I've suggested in my brief that in order to really hear the video, you have to listen to it on a device that you can amplify the sound. But if you listen to that, I think it really supports my client's position in this case, and that's that the motion for summary judgment should never have been granted. The case starts out as a routine traffic case. Between the time the police see my client and he pulls himself over in a PNC bank down there by the University of Akron, across from the parking deck, a total of 30 seconds transpires. There's absolutely nothing unusual if you watch the video with the way my client reacted to being pulled over. He was pulled over for not stopping, essentially, going right on a red, pulls up and sort of cruises through the red light. He gets pulled over, 30 seconds transpire. It wasn't until after the fact that this thing, it sort of blew up and there was a filing in this case, did the city and or the police officers really start making allegations about, that we were concerned because of the way the traffic stop went and that sort of thing. Watch this traffic stop. There's absolutely nothing wrong with the way my client drove or the way he pulled himself over in terms of the traffic stop. The video, and I pointed out some portions that we'll talk about later, but once he's pulled over, really what forms the basis for this case is a period of time that is really, if you look at the video, it's 15:40:26 through 32. And what happens is the police officer, after a while, they come up to the car. There's a conversation between them. My client's sitting in the car, and you can hear this. And I guess I'm just pointing this out in case somebody really wants, I hope someone listens to it. I'm sure they will. But if you listen at 15:40:37 through 39, 15:40:37 through 39, what you hear is they're going back and forth. And the police officer says, "Close your door." Mr. Leonhardt says, "I'd like to leave it open." And then, less than a second later, the police officer yells at him, "Get out of the car." And then you hear the things going, you hear mayhem, basically. You hear my client screaming, you hear him, "Jesus save me." You hear appear just really carnage for a period of about 2 or 3, 4 minutes while they're wrestling on the ground and they're placing him under arrest. If you listen to that video, a reasonable person, I believe, would never believe the way that the police said it happened. It's impossible to believe the way that Officer Sams or Officer Smith described the situation. And Sams describes it in his deposition at page 129 through 135. And if you listen to the tape and you consider the time component that's in there, it is impossible for it to have happened the way they said it did. Because what they say is that Mr. Leonhardt turns, forcibly throws the door open with such force that supposedly one of the officers, the badge, is thrown from his coat or his jacket that he's wearing all the way across the parking lot. And it's at that point they make a decision to arrest him or pull him out of the car. The other provisions that I cite with real particularity in my brief are snippets from that IVS system, that audio system, that where Officer Sams and or Officer Smith, Officer Sams and Officer Smith, the two principal officers who were in the cruiser. There's a couple other guys that show up later. I have not filed a brief with respect to them. Appellees note that in their brief.
What did you file in response to the motion for summary judgment?
I didn't handle the
Or what was filed in response?
in response to the motion for summary judgment.
An affidavit by your client, I'm assuming?
What was filed in response to the motion for summary judgment was a brief in response, and it was relying principally upon the deposition testimony. The deposition testimony, the IBS was introduced. In fact, the court, and by the way, out there they have Judge Collier on this case. It's not a Judge Collier case, it's a Judge Croce case. Judge Croce references the IBS in her order. So, you know, she perhaps listened to some of it, or perhaps, you know, I'm not real sure, but she references this inboard video, and she specifically alludes to it in her order. So there was the traffic stop audio tape, audio-visual videotape, the deposition testimony. The deposition testimony included affidavits that had been proffered by the city in support, particularly Sergeant Dugan ended up doing use of force. There was a use of force investigation subsequently as a result of this, and Sergeant Dugan put together a report, and I allude to that in there because the statements that Officer Sams and Smith make in support of their documents that they proffered, you know, responsive to the use of force, are really inconsistent with this IBS and really inconsistent with the other testimony also. And I alluded to that, and I referenced that in my brief. There were, to the best of my knowledge, there were no other affidavits. There was an affidavit presented by the city of a medical expert that treated Dr. Leonhardt down at the hospital. But essentially, those were, you know, the items that like I said, I didn't do it, but those were the items that were relied upon in response to the motion for summary judgment.
Are you going to be saving any time for rebuttal?
Yeah, how much have I already done?
Right now you have about almost 7 minutes left total. So
7 total. Okay, let me just. So, what I believe is the case is if you know, when you go through all this, you know, the qualified immunity, the governmental immunity, you know, the various standards under Graham or Hill, which is a case that the state cites kind of as a backup to Graham, which in the Hill case doesn't even apply because there was no medical emergency and there, you know, that sort of thing. If you listen to this, it's more than apparent that there was absolutely no reason to arrest Mr. Leonhardt before he was pulled out of the car. Absolutely none. And the deposition testimony supports that because Sams and Smith really essentially say that the probable cause to make the arrest was being struck by the door. If you listen to the tape and you listen to the specific portions that I point out in my brief, these guys never mentioned anything about this door incident to anyone on the scene. In fact, there's one statement in there that really contradicts. He says the one officer at Smith or Sam's, and the state says, well, you can't tell who it is. It's either Smith or Sam's, says, well, he almost hit me with the car door. That's in the tape, if you listen to it. So, when you take a look at the totality of circumstances and the statements that are made, there is clearly enough to get to a jury on this case. And the court really, in my opinion, if you read the decision, went out of its way to grant the motion for summary judgment with some of the statements that they make. But if you listen to that tape supports the proposition that this thing really should have gone to a jury based upon a lot of things that happened there's incredibly conflicting testimony in this case, and that's one of the reasons why it should have gone to a jury. Thank you.
I do have a quick question.
Sure.
And it concerns any injury suffered by your client. On the one hand, I think the city is saying it was a bruise. I believe in your brief you said a broken arm.
He did incur a broken arm. If you take a look at the motion for summary, or the response to the motion for summary judgment that was filed in this case, there are some pictures in there, colored pictures of my client that show some of his injuries, some of the bruising, some of the, some significant head trauma from where his face was pushed into the concrete while he was on the ground and being detained and handcuffed and that sort of thing. So there's pictures and there's a dissertation in the response to motion for summary judgment that address some of his particular injuries.
Thank you.
Good morning, Your Honors. Brian Bremer on behalf of the Appalachian City of Akron and the officers in this case, Officers Smith, Sams, Hunt, and Mann. And I just want to reiterate the point. Council has conceded that he didn't challenge the summary judgment award as applies to Hunt and Mann. So regardless of what happens in this appeal, the summary judgment as far as those two should be affirmed, and they should be out of this case at this point. I wanted to briefly touch on some of the assignments of error that were raised by Appalachian before going into the excessive force. As we point out in our brief, there's two assignments of error that go to manifest way insufficiency. Those aren't proper assignments of error for the motion for summary judgment. There's also an assignment of error dealing with the petition for the grand jury testimony. The grand jury testimony issue is an abuse of discretion standard, and there's no authority cited to really, and no argument developed about why the facts of this case rise to the level of a particularized need. And it's important to remember that that's not a summary judgment review for that assignment of error, just because you don't need to read the testimony in this case in the light most favorable to Dr. Leonhardt with regard to trying to get to the grand jury. It should be read, and the court is allowed to weigh the evidence there, and there are a lot of reasons why the court did not need to get to the correctly rule that Dr. Leonhardt had not shown a particularized need to unseal the grand jury testimony. The other issues that kind of flow through the briefing here are that appellant has not argued the facts of the case and applied them to and under the law. The arguments for each assignment of error essentially go with a recitation of general case law followed by a summary about what they believe that based on the facts of this case there's a genuine disputed material fact. This court has held that the appellant's burden to actually show that and explain why the fact is material to this case. And under all the different assignments of error, that showing doesn't happen because there's never an analysis of what the facts are and what the facts and how they apply to the law in this case. And where that is most apparent is in this discussion about the video and the audio that's in the video. And one thing I want to point out is that even in his brief, it's not the officer that's speaking doesn't say he almost hit me with the door. he almost hit him with the door. So all we know is that it's not Officer Sams. Officer Sams is the individual who's at the car door and that Dr. Leonhardt opens into him. No one else, like that's not Officer Sams talking, and there's no reason to believe that it's Officer Sims necessarily, because there's many other police officers on the scene of the accident, scene of the incident at that point. And so it's unclear who is making that statement, and even assuming it was Officer Smith, and even assuming that it creates a dispute of fact about whether Officer Sams was struck by the door or merely almost struck by the door, it's not material because it's still either an assault on a peace officer or an attempted assault on a peace officer. If I walk up to a police officer and take a swing at him, I can't then say, and I miss, I don't get to say, you can't arrest me because I didn't actually hit you. What happened, even in the light most favorable to Dr. Leonhardt, the incident with the door was enough to justify the officer asking him to step out of the vehicle, and they were going to place him under arrest. There's evidence in the record that Dr. Leonhardt grabbed hold of the steering wheel. Regardless of what happened right then, though, the officers and Dr. Leonhardt ended up on the ground. At that point, it's a very dangerous struggle for the officers. And it's important to always remember when you're evaluating these qualified immunity cases, you shouldn't be doing it from the state of 20/20 hindsight. You need to do it from the state of the officers in the moment. What are the objective facts known to the officers before them? And unless their conduct rises to the level of being clearly unconstitutional, that means there's case law out there that clearly establishes that the facts of this that happened here make what they did unconstitutional, they're entitled to qualified immunity under the federal law. And the officers here, there's no case that's cited by the appellant in his brief that shows that what the officers did in this case was clearly unconstitutional by well-established law. The officers asked, the entire incident was based around this issue with the door. The officer told Dr. Leonhardt that the door needed to shut. Dr. Leonhardt can be heard on the tape saying, I don't want it shut, I want it open. And then something happens with the door. Officer Sam says he was struck by it. The IBS video says someone was maybe almost hit by it. Regardless, Dr. Leonhardt admits he put his hands on that door and to keep it open when the officer tried to shut it. At that point, the officer tried to bring him out of the car. They fell to the ground. And then Officer Sams never struck Dr. Leonhardt. That's clear from the record in this case. Officer Sams never engaged in any strikes or used any pepper spray in this case. So the excessive force claim against Officer Sams was correctly dismissed on the summary judgment because there's no evidence, even viewed in light most favorable to Dr. Leonhardt, that he acted in an unreasonable manner with the force he applied. And when it comes to Officer Smith, you can hear on the video, they repeatedly tell Dr. Leonhardt to give him his hands. It's clear he's not giving their hands, and then at that point, Officer Smith escalated to a low level of use of force of striking Dr. Leonhardt in the buttocks and the lower leg. That is not vital areas of the body. Those are not going to cause substantial injuries. This was not a gratuitous act. This was a simple act to try to get compliance from a non-compliant individual during the course of an arrest.
Did you agree he broke his arm?
No, there's no evidence that he broke his arm, or he broke it. There's no evidence that an arm was broken as a result of the incident here. He was checked out by the EMS workers, he was checked out in the hospital, and every expert that's involved in this case has said that there was no physical injury like that.
Did he immediately go from the emergency room to the 3-day hold?
Yes.
So he was in the hospital for an additional 3 days after the initial emergency room visit?
He was pink slipped by the attending physician, yes. So right after he went to the EMS to the hospital, then he was on a 3-day hold.
So he had at least 3 days in the medical environment.
Correct. Once the officer, when he still did not give up his arms, then the Officer Smith used 2 3-second sprays of pepper spray, and that eventually led to compliance from Dr. Leonhardt giving up her arms.
So is this a case that involves the doctor being non-compliant as opposed to threatening or dangerous to the officer?
No, it goes beyond just merely being non-compliant. And it's something when you hear the video, you can hear throughout the stop, Dr. Leonhardt is very agitated. He's consistently screaming before the. He charged the officers when they stopped him. He jumped out of the car and charged at the vehicle, and resulting in the officers having to draw their firearms to get him to stand down. And then they figured out, and Dr. Leonhardt offered an explanation for why he did that, but if you watch the video from beginning to end, you see Dr. Leonhardt go through the red light. It's not a casual, like you're going 25 and you barely make it, you just the light changes and you can't stop in time. Dr. Leonhardt speeds through that light, makes a hard right turn in a way that's incredibly reckless if you watch the video. And so the officer saw that, and then when they followed him, he, instead of pulling to the right, he pulled to the left, which is not an inherent sign of anything, but it is unusual. And then when he pulled off to the side and they followed him, he stopped and then accelerated again, went in and stopped again in a parking lot. So basically, he seems to be leading the officers to a place of his choosing for the stop, not where the officers, not the most convenient place for the officers. And then when they actually pull behind him, he leaps out of the car and charges at their vehicle. The officers have, at this point, have reason to see that there's something unusual happening here. And then when they actually calm the situation down, they holster their firearms, they get Dr. Leonhardt back into his vehicle, you can hear he continues to be agitated, extremely agitated throughout the entire encounter. And then there's the incident with the door where he either struck Officer Sams or he almost struck Officer Sams at the door. If you want to take the absolute best case of facts imaginable for Dr. Leonhardt, he just merely almost struck him. Officer Sams tries to arrest him, and then he engages in behavior where he's not giving up his arms on the ground. And the question is not what Dr. Leonhardt's subjective intent was during that incident. It's what the officers could reasonably, objectively believe the facts to be under this incident.
Did the officers at David state they were concerned that he was going to grab a gun or something like that?
The officers did not talk about the idea of the firearm during the depositions of the affidavit, but it is a reality of the situation when they're on the ground like that.
But objectively, wouldn't we look towards an affidavit as to what the officer thought at the time?
You could use the officer's subjective belief is important for some aspects of how they're reacting to the situation, but it's still an objective fact that the gun is near Dr. Leonhardt. So even if the officers weren't necessarily thinking about the gun, that is an objective fact that should be considered when you're looking at whether or not what they did was reasonable under the circumstances here. And again, it goes to the idea of Dr. Leonhardt may have been not intended to be actively resisting, but the officer is definitely feeling resistance on his arms, where when they tried to remove his arms from underneath him, they could not get them out. And the officer, it was a reasonable belief for the officers to believe that he was trying to resist their attempts to get the arms out. And when they engaged in low-level force, he still didn't give them up. So everything the officers did in this case was a very reasonable, slow escalation of the actual force they were using to try to achieve compliance of the individual who is refusing their commands and is not letting himself be secured in handcuffs. And one last thing I want to touch on before my time is up is that with regard to the malicious prosecution claim, the trial court found that it concluded that there was no evidence that Dr. Leonhardt had the case adjudicated in his favor. That's an element of both the federal case and the state case. You have to have the claim adjudicated in your favor. There's no evidence in the record that the claim is adjudicated in his favor. So he can't meet that element of the offense. He's not actually challenged the trial court's decision on that element. And as this court held in Stevens versus Akron, the failure to actually challenge all the different parts of the alternative reasoning of the trial court is a reason to affirm the trial court's decision, because you have to actually articulate why the trial court was wrong. Unless there's any further questions, we would respectfully request that this court overrule the assignments of error and affirm the decision of the Suffolk County Court of Appeals, please. Thank you.
Turn it on, we have 3 minutes and 45 seconds.
minutes 45? Yeah, quick. Listen, the entire basis for what Smith and Sam's, the justification for the entire thing that they did to Dr. Leonhardt is based upon Dr. Leonhardt forcibly hitting Officer Sams with a door during this episode. The IVS doesn't support that. For the city to sit here and say that it's all speculation, who said that in the video, that I've given you the specific provision, is a ruse and silly, because there's no mention of this door incident whatsoever on the IVS. So the only two people that knew about this concocted story about the door were Smith and Sams. If it's, therefore, there is no one on the IVS other than Smith who could have made the statement that you hear in that video that he almost hit him with the door. That's the entire justification for them dragging him out of the car and doing all these things to him. And if you listen to that snippet that I told you about the IVS, it supports the position that it simply did not happen. And when you talk about, with this immunity and everything else, fabricating a story after the fact, if that isn't bad faith, I don't know what is. And that's what unfortunately happened in this case. Because you can also hear, if you listen to that tape very clearly, at some point in time, Smith and Sams are heard talking, well, what do you want to do? Do you really want to charge this guy? They're having this dissertation about whether they even want to charge him. Well, the reason why they ultimately charged him is because of the injuries he sustained, and they knew they had to at that point in time.
Could it also have been that he was demonstrating some mental problems that they were being...
Well, but that's not to arrest him. I mean, that might have been to take him somewhere to see what was wrong with him, but, I mean, not to arrest him. They'd say, the only reason why we arrested him is because he hit him with the door. He didn't hit him with the door. You're going to listen to that IVS, you're going to listen to the statements. It didn't happen. So if that didn't happen, what was the reason to drag him out of the car, and what was the reason to arrest him and everything else? All the rest of the stuff is a ruse. Just lastly, the state also alludes to an indication of case law. If you take a look at the response to motion for summary judgment, counsel went through a litany of cases that they perceived to be demonstrative of the care that's violated, but the state also misstates the law. The law is that if there's something that happens that is such that it would certainly clearly be understood to be wrong, you don't have to point out a case specifically to point. And that's the Brody case, 9/11 Federal 2nd, 1179 6th Circuit, 1990, which I cite. So, notwithstanding that fact, it was done, and in an instance like this where you clearly know that what you did was wrong, or it shouldn't have happened that way, there's no affirmative duty on that part to find a case. And this court knows that that cases are every case stands on its own merits, own facts, but there was an indication of those cases in the response to motion for summary judgment. So in summation, both Sams and Smith pulled Mr. Leonhardt out of the car. Both of them put him on the ground, handcuffed him, pepper sprayed him, kicked him, kneed him. Both of those two did. They were both there. And if you listen to the video and you take a look at that Sergeant Dugan's report is particularly interesting, because if you read, what he based, the facts that he based his incident, his lack of finding of on that particular use of force, it's really divergent for what you're going to hear on the IBS. So, I mean, I just ask you, if you're going to listen to the IBS, don't listen to it on your laptop. Listen to it with something that's got some clarity so you can hear it. And listen to the whole thing, because there's nothing at all about this door opening, that the door hit me so hard it almost knocked me off my feet. My badge flew across the parking lot. It chipped my badge. It just didn't happen. Thank you.
Thank you both for your presentations today. The court will take the matter under advisement and issue a written decision which will be mailed to both sides.